Good evening, everybody. Welcome to another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela. What's going on, my friend?
I feel good. It's been a month, 4 weeks off. We're back live. I feel good.
A lot has happened in the month.
It has. A ton has happened in a month.
There's no way we can catch it all up tonight, but we're going to try to with two, very people with soft-spoken and not a lot of opinions. No. Two past presidents of the Harris County Criminal Lawyers Association join us this evening. Ladies and gentlemen, Robb Fickman. Robb, how are you?
Good evening. Good evening.
I'm glad you could be here.
Thanks for inviting me back on the show. I don't usually get invited back to places.
You've been invited a couple times here.
Well, you all make mistakes. What can I say?
You know, what's the definition of insanity?
Yeah.
Yeah. And also joining us, Todd Dupont, former host of this show as well.
A few years.
Glad to have you back.
Thank you for having me,
when was the last time you were on here? You came on last
probably
year.
About a year ago.
Yeah, that's what I thought.
I think I had long hair back then.
I
think you had long hair on the face.
Southern General routine.
I've had a number of looks on the program.
You know, it's important in our business to change your look on a regular basis.
I think he was in the midst of a Civil War reenactment, I think.
Never know.
I was in the midst of a lot of things.
Yeah.
He's the only man that I know that while with the ZZ Top beard and hair as it was, to get a not guilty on a one sentence close. It happens.
It happens.
Mr. Dupont, ladies and gentlemen.
On a what?
On a cocaine case.
Oh, well.
I lost my first trial after I cut all facial hair, and I was a little bit aggravated at that.
Yeah.
The superstition. Got to.
We have those.
We got a great show tonight, ladies and gentlemen. We got a lot of good topics to talk about, including we're going to get to talk a lot about special prosecutors and special counsel this evening. I know Mr. Fickman has no opinion on that subject, ladies and gentlemen. Zero opinion on Trump whatsoever and what's happening. But we'll get to that a little later. We're going to have Twitter up all night at HCCLA_TV. So you can send us your questions and comments there. We'll also open up the phone lines around 8:30, 713-807-1794 is the number, so you can jump in with your questions and comments. I'm sure there'll be a lot for you to get in on if you want to this evening. But let's start, guys, with the big news locally. I want to start locally first, and then we'll build our way up to the national scene, if you will. But the big news over the last couple of weeks has been, of course, the Harris County bail bond lawsuit in federal court. We've been talking about it a lot on this show. We kind of predicted that Judge Rosenthal was going to rule the way she did, and she declared the Harris County bail schedule for the misdemeanor courts unconstitutional in a 193-page opinion, which was scathing, just scathing. The county hired, it's kind of weird because you have both the county attorney's office and outside counsel representing the judges. You've got one county court judge who says, settle this damn thing. We don't need to be a part of it. Judge Jordan, the others are still fighting.
Kudos for him to standing up to do
exactly. And then you've got the county commissioners who don't want to settle it, I guess, other than Rodney Ellis, who's now back in the county commissioner's spot. And so there's a lot of dissension. The DA's office, the sheriff's office, they're all in support of this. And what happens? The county decides they're going to appeal the ruling.
Right.
So what was supposed to go into effect this past Monday, May 15th, has now been stayed by the Fifth Circuit Court of Appeals, pending the appeal of this injunction.
What does that mean, though? So,
it means they can continue to do what they've been doing for the last 30 years.
Right. And Robb, I mean, you've been the most outspoken about this issue for a number of years. Seems like every time you come on our program, you aren't lacking of anything to say about it. So I wanted to start with you and get your thoughts on the lawsuit, Judge Rosenthal's ruling, and the appeal.
Okay, but there won't be in time for anybody. Okay, no,
I'll cut you off. I'll cut you off.
I know
Don't worry.
The system that we've had in place for 30 years, as these guys know, and Todd's been involved in this issue as well, and trying to get the judges to do right, is the judges have systematically denied PR bonds. We're talking about the county criminal court judges that handle misdemeanors, as you know. And they have systematically denied PR bonds to poor people who could not afford to make a bond. And so as a consequence of that, the poor people have been left in jail and then they would be brought to court and they would be given an option, really no option, but this is what they would be told. If you plead guilty, you can get out today or maybe tomorrow. If you plead not guilty and want to fight for your innocence, well, we'll come back in a month or two. Now, these are poor people that need to get out and feed their families, so typically they pled guilty. Typically their lawyers spent no time with them, and so we refer to this system as the plea mill. It is an abomination. The 15 out of the 16 county court judges that sit right now have perpetuated this system. There's been a tacit conspiracy, in my opinion. And what happened was a civil rights group really came to town that sued around the country, and they engaged and got with one of the big law firms that had some power, and they filed a giant lawsuit against the county, and it went to federal court in front of one of our very best federal judges, who's very honorable, Judge Rosenthal. She heard lots of testimony. She heard from Judge Jordan. She heard from a lot of people about how the system worked, and she was aghast. The county court judges are used to doing this to people, and so they justify it to themselves. The federal district court judge, who is not used to this sort of abuse, was aghast, and as y'all said, that she issued a scathing opinion saying they needed to stop it and they needed to immediately start granting PR bonds to these poor people on misdemeanors. And what did they do? They filed an appeal. That is, the county commissioners filed an appeal, and what that did is that stopped the judge's order, and in layman's terms, that meant that the county courts get to keep abusing poor people by systematically denying them PR bonds, and systematically putting them in that position where their choice was plead guilty and get out today, plead not guilty and get out later. Basically, what it boils down to is in Harris County, if you're poor, in order to get your liberty, you have to plead guilty. And the system that's based on that, sorry, I'm getting pedantic, but any kind of system that's based on that, where a poor person has to plead guilty to get their liberty back, is a system that is immoral.
Todd,
Now, not that I have an opinion on it.
Right. I mean, Todd, how can, at this point, with 193 pages of a ruling from a very well-respected judge, how can the county justify appealing this issue?
Of course, the wheels of justice seem to turn extremely slow. Each one of these judges could today or yesterday or a few weeks ago decided to, regardless of the lawsuit, do their own thing, just like Court 16 did. They're not interdependent upon each other. Perhaps they would like the Supreme Court or somewhere else to give them direction, but right is right.
What is the...
And all the stakeholders, really, other than 15 county court judges,
Right.
really seem to agree with the federal judge.
Yeah, the DA,
Right.
the sheriff who wants to clear out his jail, not use his jail to house people that are charged with misdemeanors, not convicted even.
It seems like the major stakeholders are in agreement with the tone and direction of where the federal lawsuit seems that it will end up. What's disturbing is how much money
Yeah.
the county is using to defend this lawsuit and pay other lawyers, when perhaps that money could be directed towards other situations in our county. And that when the smoke settles down, that is going to be one of the more egregious things of the lawsuit, the amount of money spent to defend a system that's broken and constitutionally wrong.
I agree.
What is the next step? So the judge ordered not only more people who are recently being arrested for misdemeanors to be granted PR bonds, but to let out all the individuals who are in the jail for lower level misdemeanor crimes to be released. So what is the next step that the Fifth Circuit has said no to stay the judge's order? And so what's the next step? Do they go to a trial on the merits of this?
Well, actually, the plaintiffs who filed the lawsuit against the judges have filed this week. They have filed a petition with the Fifth Circuit to reverse their decision and go ahead and impose Judge Rosenthal's order. But in the meantime, as Todd was just describing, the system will continue unless there's something different. It will just continue. Todd, you referenced how much money is spent. The viewers might be interested to know that the county has spent $3 million defending this immoral system.
That number was 2 weeks ago.
Yeah, it's more than that.
We have to think that we're encroaching now. I mean, these are $500 an hour law firms and things like this. The money is going to get out of hand. Now, I will say this. Today, I went to 701 San Jacinto, a Harris County jail, one of three. Well, there's 3 or 4. Usually they have 5-inch binders for the inmates, and I've never understood if they update them daily. It seems like they need to, because if somebody comes in, they need to find their defendant by spin and so forth. The binders were both A through whatever, F, they were 3-inch binders. It wasn't a big binder, which to me means there's less people in the jail.
Maybe.
Well, they weren't 5-inch binders. I made note of that. I thought that was interesting because we've all walked in jails and seen there are 2 binders and they're 5-inch, ring binders. I don't know if that's cause and effect of the lawsuit, if there is progressive change going on, but we collectively don't see each part.
Well, and how much is the non-prosecution of Class B and Class A marijuana offenses too?
That's probably part of it.
I mean, that also could factor into
Yeah,
this.
I'm telling y'all, they were small binders.
I think this is an attempt for the misdemeanor judges to try to show that, oh wait, the reforms that we're implementing are working. However, I have recently had an individual not on it was actually a driving while license invalid, which is the same type of plaintiff that that was used to spin this lawsuit, to commence a lawsuit, where the issue was that they couldn't verify his 2 phone numbers. That was the problem. This particular judge did not release him on a PR bond. They just reduced the bond, which is not what the goal was to do. Their goal was to release this guy. It was a driving while license invalid. Release him, let him clear his license. Let's do it the proper way. And
They take their phone, and nobody remembers phone numbers.
Everybody's cell phone.
Of course.
Right.
And when they take the phone in the property, nobody, when they're interviewed by pretrial, can give 2 phone numbers.
They can't access their phone.
right.
Well, I believe there is a trend that they're allowing numbers because I've seen my own clients have small pieces of paper. It's crude with 3 numbers on them. The question is that a commonplace practice? Is it who's working the desk that night? It is not a form. I've often just seen it on scratch pieces of paper. But pretrial won't, and when I was president, this issue was ripe. And the court said, we can't let them out on a PR bond if we can't verify a residence and a contact. That was the 2 questions. Our response is HCCLA's response was, well, we can't give you 2 phone numbers if we don't have access to our phone. Nobody remembers phone numbers.
Look, one of the issues now I agree with what you're saying, but one of the issues that we have here is good faith and bad faith. And, we're talking about our county criminal court judges. We know them, and as far as, having a trial in front of them, they'll give you a fair trial, most of them. But we're talking about a policy here that when implemented and perpetuated by an entire group, does a lot of damage. And it's gone on for 3 decades now. And the bad faith here is that these are intelligent people. They know what the plea mill is. They know that that people are ending up getting cornered and forced to plead guilty. And yet they're continuing to perpetuate the system and fighting to keep it alive. This is what's really disgraceful, is that the judges are intelligent people. And what has their defense been? Their defense for perpetuating the system and not granting PR bonds was, well, you know, we had a system that was broken and we couldn't analyze people because the tool for analyzing whether or not people were in danger was broken. The tool, that is the evaluation.
Pretrial services.
Yeah, their tool.
Created.
And that's what they said was their reason, that our pretrial services tool for evaluating people, whether or not they would return to court, was broken. And they said that that was their reason. Now, in all the years I've talked to the different judges, I've heard lots of different reasons. That was never the universal reason. That was just one of many reasons. But they all agreed, not on the reason why they were doing it, but they all agreed to do it and perpetuate it. What I would say to that is, if the tool for calculating the judge's salary was broken, they would have fixed that 20 years ago. And I'm having to work real hard not to use obscenities right now, because the truth of the matter is that is just a fabrication. Whether or not they believed it or not, they could have fixed it a long time ago. It's an excuse for continuing to perpetuate a vile system. And shame on them. Shame on them. And these are intelligent people. These are not bad people. These are people that are perpetuating a bad system.
I will say, and what I think is happening is that the county is trying to put together a good packet, so to say, to show, like, look at all these reforms we're doing.
Right.
We're doing well.
Right, but you know what? For too long, they've done the wrong thing. So they lack credibility. And then they got money. They got the MacArthur grant. They got awarded money. This county was awarded money to fix problems that it created. Talk about irony. So you go out and you screw up your own system and you abuse poor people, and then you win a grant to change that.
Well, and how do you sit there and say we're changing the system when you have a number of judges who are also being an impediment to granting of pretrial diversion?
Right. It's not.
You can't say on one hand, we are reforming the system, when you are standing in the way of a district attorney who is trying to herself reform the system by granting people pretrial diversions
That changes
on
just
a lot more things.
the idea a little bit, but it's still a judge thumbing their nose to the ideas of what justice becomes in a criminal case.
Look, and this is.
But it all starts with bail.
Right.
Yeah.
And if somebody is cornered into pleading guilty, we don't know whether or not they were innocent or guilty. We never know. And so there's presumably many people over the years, poor people that have been coerced essentially into pleading guilty, who are stuck with a criminal record. And some of the judges said to me, well, we can't grant them a PR bond because, Rob, they have a criminal record. I said, well, Judge, if you look at that criminal record, you'll see that they pled on their first day in court because of your friggin' system. And in 2013, I wrote a letter to all the judges. It made me real popular with the judges, I can assure you. And I asked them as nicely as I could to increase the granting of PR bonds. And what happened after that, there were a few that wouldn't speak to me anymore, and the glaring was nice. But what happened after that, Todd was president, and Todd went and met with, why don't you, Todd? You went and met with one of the judges and tried to push this. And Todd did his very best to push this on behalf of HCCLA, and with the best effort, they were like what? They were like a brick wall. They wouldn't move, right?
Judge Ross told me to my face. He and I sat. I expressed my concerns with regards to having access to phone numbers, and I believe in his. And Judge Ross has always been honest. I think he's a very good judge. He was granting PR bonds back then. I don't think necessarily, you have now 16 different castles, right? Judge Ross understood the angst that we had with regards to this issue. It wasn't on the forefront. I mean, we've been pushing it. We certainly had been pushing this issue. But what Judge Ross has indicated to me was that he's going to look into that and fix it, and I trusted his word. And
here we are 4 years later, and there's a lawsuit.
I'm not espousing any of this on Judge Ross. This was my communications with the court. He was the presiding judge.
Right.
I will say, no less than, speaking of Judge Ross, in no less than 4 cases, I approached him this week, and PRs on all of them, which I don't necessarily know if he's a visiting judge and just being like, I'm going to do whatever I want to do, right?
But the idea is, if it's if that is the right thing to do, and I do believe even back then in 14, that Judge Ross believed that's the right thing to do, just because he believes that's the right thing to do doesn't mean everybody else is going to do the right thing.
Well, also, let's look at the statistics. In the county courts, there's about 50,000 misdemeanors a year filed in Harris County. They were granting less than 10% on those cases. They were granting on less than 10% of those cases were they granting PR bonds. And that's been the historical trend for years here. And so there was no wild granting of PR bonds. They were systematically denying them. And it's a whole different deal, Jimmy, but the magistrates are the ones that set the initial bond.
Right.
The magistrates work for the county courts, and the magistrates were afraid to grant PR bonds because if they granted too many PR bonds, like there was one magistrate that did, he got
fired.
Goodbye.
Yeah.
So they needed you know what? The only way
There was a scandal with the magistrates.
yeah, that's true. They are abusing people.
you really
The only way
think-
this is ever going to end, like some bad things in our country, have only ended when the federal government has gotten involved, and that's what's happened here. We have a very highly respected jurist, and I'll call her that. Judge Lee Rosenthal is as respected as they come. She wrote a brilliant opinion, and justice will come when that opinion is followed, and not until then.
So what's your prediction? What do you think happens ultimately at
think
the
it's
federal
gonna-
level?
I think it's going to take another year, and ultimately it will settle some fashion where most of what Judge Rosenthal has ordered happens. But I think the county will do everything it can to drag its feet for bad motive. I don't know. What do you think?
Yeah. What's your opinion, Todd?
I would hope that the undercurrent shows these county court judges, because quite frankly, at least 3 or 4 of them aren't running again. They're not going to be here in 18. Of course, I believe there's going to be a lot of people lining up to run, and I would imagine that'll be an issue that they're going to run a platform more on. With regards to the end of the federal lawsuit, I believe Rosenthal's opinion will hold, and we're going to see that they've spent millions of dollars, good money after bad. That's my opinion at the end of the day. And
I agree with
and
you.
Harris County is going to be disgraceful. Look, they don't have to defend this bad position.
Right.
This lawsuit could be over in a phone call, maybe 2 or 3.
Well, and as you said, there are county officials who are siding with the lawsuit. I mean, our DA is
Almost
siding with
all
it.
of
The
them.
sheriff is siding with it. These are not left-wing ACLU people. These are law enforcement. These are the top law enforcement agents in
When
this
you
county.
have the sheriff and the district attorney of a county this size, which is very
Right.
unique in the United States, saying they agree with the federal judge,
Yeah.
isn't that enough?
Yeah, it's basically
Really?
stop
Isn't that
picking on
almost enough?
It's this. Stop picking on the little people that are charged with small offenses. Give them a chance. Give them PR bonds so their lawyer can actually try to investigate their case. If they're not guilty, maybe they'll be found not guilty. Maybe the case will get dismissed. It's not going to get dismissed if they're forced to plead guilty the first day they go in. And by God, they wouldn't do it to their own family. So you know what? Shame on them for all the years they've done it. Shame on them. Shame on you for all the years you've done it. All of you. I would name you right now, but I don't have time.
The other big story locally that's been
You don't want me to.
How do you
Well,
follow that?
because we got to transition.
Yeah, I know,
right?
transition.
I mean,
I just made myself that much more popular.
I didn't have a natural segue. From,
Yeah.
You know,
Rob's angry rant.
I'd
Now
name
you
you if I
do.
could.
Okay.
So
Well played.
I know, I try. Our DA, Kim Ogg, of course, has been dealing with this highly publicized case of David Temple for a while now, since she took office. And she came in and said she was going to review the case and decide what her next step was going to be. Well, we found out last week that step was she was going to recuse herself. A lot of people were predicting, a lot of the naysayers were predicting that she wouldn't do it. A lot of people were calling on her to do it, that it was the right thing to do given the connections that her office had, multiple connections that her office had to the case. And lo and behold, she did it. And today we got special prosecutors in the form of the Texas Attorney General's office appointed by the new judge in the 178th, Kelly Johnson, to now take over this case.
Where are they from, do you know?
They are, well, you have Lisa Tanner, who I believe has been with the AG's office for a while and tried several high-profile cases, and then you have the former Brazos County DA, Bill Turner. Okay. So they're the two that have taken over the
I
case.
think Kim Ogg, to make that decision is the right decision. I think
Yeah.
anybody that's followed this, even as a passing, would agree it's the right thing to do. The only question is, why did it take so long? But perhaps she wanted just to instill in her mind and ideas that it was the right thing to do.
Well, but you say that it took her so long, but what I'm impressed by, and certainly you can criticize our DA for a lot of things, but what I've been impressed by so far is that she does really think out her decisions. She's not one to make a snap decision about things. I mean, she went in with a transition team. She started looking
Well,
at
some
stuff.
would argue against that.
What?
Well, firing people by email.
Agree, and that's what I'm saying.
Okay.
There's a lot to criticize her for.
I mean,
okay?
that might be a snap decision.
I agree
There
with
was
that.
nobody brought in to have a
But-
meeting about thank you for your service.
I agree with that. But what I mean in terms of some of the policy decisions, the non-prosecution of Class A and Class B misdemeanors, the expansion of pretrial diversion programs, these decisions about how we're going to recuse ourselves from office. I mean, I think with regard to the really big picture legal issues that are out there in the forefront, I think she's making the right call. She hasn't had a misstep, guys, to this point.
Well, one thing I would compliment her on is that she's taken people that were former prosecutors who were on the defense side but started out as prosecutors and brought them back into the DA's office. And these are lawyers with 30 years worth of experience. And I think it adds to the integrity of the office. It gets, they're not that young, but they're fresh blood in that office. And these are people that are very committed to justice. And she's also brought over some people from the U.S. Attorney's Office. So it's kind of getting a fresh start, if you will, from the DA's office, getting us away from the Chuck Rosenthal gang, the total disgrace, and getting us to people that are in positions of authority there that are well respected on both sides of the bar.
Something that's new that I'm not sure most know about, or the viewers, generally before DA Ogg, you got caught with prostitution. There was no
I did?
yeah, there was no AIDS, AIDS class and dismissed, community service dismissed. It was usually they went after the Johns pretty hard, and so I had a.
There's just a lot of double entendre.
Well, I had a recent client where it was a perfect sting.
Right.
It's on back page. It's on video. It's on audio. He comes in. He puts
just keep
the
going,
money in.
JV. I'm enjoying this.
He puts the money in, and and it's an obvious setup, and he knows it. Everybody's getting nervous, and the cops bust in, and the guys should be a good pretrial intervention kind of guy that would have been denied flat because they got him cold previously.
Right.
So we go in, and we're about to set this thing for trial because this guy can't. That's a bad label right across your forehead.
Yeah.
And I'm about to set it for trial, and the prosecutor says, "Oh no, we have a new directive for Johns in this particular scenario.
Got one today myself.
It's an
What is it?
AIDS class, community service, Nolly. Take
I
the
had to do a
T-RAS.
T-RAS.
Take the T-RAS. After that,
T-RAS.
It's a risk assessment test one has to take.
Oh, to make sure that they're not bad guys.
Well, it's just I guess,
Then the
high
AIDS
risk
class,
or low risk.
right.
Kind of like don't go out and hire a prostitute.
Right. You learn about the dangers and such.
Decision making.
To me, it seems like
Help me
they just
decide what
look
to do
at
on the
somebody's criminal history.
Yeah.
Look, Dr. May could, and you might consider having her on. She would be a really good guest for you.
We consider anybody on this show, Todd.
Obviously.
She's
Very loose standards
not
on who
for
gets
the
on
not
this
for
show.
the new season show though. Not for the new season.
I don't think there's any standard for this show. I mean,
All right,
well, at
any
least for
event.
me.
It's the new thing. And so this guy who generally would have had to go to trial, take a deferred, or get some sort of conviction, now has a new shot.
So, hey, if you were thinking about it, no, I'm not.
Well, all right. So is it the idea that perhaps any of the naysayers of DA Ogg just needed her to settle in and let some of her ideas come out and flesh out? Is this
I
what we're
think they'll-
seeing with her?
I think there'll always be naysayers. I mean, the
Yeah,
bottom
but-
line is we're going through a political and cultural, change in this county. And I think there's a lot of people who are
Upheaval.
Yeah, and I think there's a lot of people who are unwilling to accept it. And,
Yeah.
and she is the change right now. She's kind of the front and center of the change because what she's doing is such a radical departure from what's been done in the previous administrations that I think she's never going to please everybody. But I do think you're seeing a shift in a lot of things, and that's going to bring me to the next topic. But I want to let everybody know we're going to open up the phone lines now.
Already?
It is 8:30. Yeah, it's 8:30.
That's
We're
about quick.
halfway through. 713-807-1794 is the number. I still have Twitter up. You can communicate with us here, ladies and gentlemen, at HCCLA_TV.
I probably just should answer. This will save a question. Aquarius. Okay, go ahead.
Yeah. Swipe right.
Also, shout out to a friend named Mike who's had a rough road. He's on a good road now. Hey, Mike.
There you
Thank
go.
you. Sorry about that.
No, but the opposite is happening at our national level, and we're gonna build this into a crescendo. But last week,
I'm just happy we haven't been incinerated.
well, that might be coming next. But last week, our Attorney General issues a directive for U.S. attorneys' offices now to go and seek the highest charges possible, to reinstitute the charging of any case that has a mandatory minimum sentence, and you are to seek the highest sentence possible under the laws. I mean, just a complete, not only 180 reversal from what Kim Ogg is doing here locally, but a complete reversal from the changes that had been done.
The DOJ.
The last 30 years.
Yeah.
Well,
for
at
at
least
least
for the
last
last
8 years.
Yeah, under Obama and Holder.
There's certainly a trend to move that way.
And
It was called enlightenment, and he's going backwards.
He is.
Probably because he thinks it's 1858 and the Civil War is about to happen or is going on.
And dinosaurs lived with people. And
Beauregard or whatever his name is. I mean, this is a bad thing.
It's a horrible
thing. And the U.S. attorneys who are experienced federal prosecutors know that they need to have leeway and have discretion, just as the district court judges do in federal court, and that when you order max everybody out, is that really going to achieve justice? No, it doesn't achieve anything like
He's
justice.
going to appoint people that will follow his missive, much like a Sean Spicer or whoever else he puts up in front of people, and he's going to send that down to his line assistant United States attorneys who have to abide by that missive.
No thinking allowed, no discretion allowed,
Now,
just follow the rules. Go stand on the rubber line.
Me, and y'all correct me if I'm wrong, I've been on the panel since 7, where I was focusing the last decade on criminal case or federal criminal cases, half my practice. But it seems to me they would always charge the highest charge, just not necessarily seek the highest punishment available.
That's
Meaning,
true.
Some jurisdictions might tweak that a little bit. If you seek bond, then we're not going to offer a 5K1. In Florida, I had one where if they indict you, they don't dismiss charges. You either plead to all or go to trial on all. Like we've had pockets, right, of federal jurisdictions where they always brought the highest charge that they believe they could prove beyond reasonable doubt. That was a missive from the DOJ.
Right, that's always been.
I don't.
And they filed
that's
an
in the
exception.
U.S. Attorney's Manual.
Yeah, and I
okay?
don't think
But-
Sessions changed that.
No, but it's the outcome that counts.
Well, but what he did change was there was a rollback on that, okay? So
Right.
the U.S. Attorney's Manual does say that prosecutors are obligated to charge the highest possible charge. But I believe it was in 2009 or 2010 was the beginning of the Holder memorandums on charging. And I think the most recent one was about maybe a year or so before he left office, where there was a formal rollback of charging decisions and using discretion in what to charge. And this basically reverts back to what the default is in the U.S. Attorney's Manual, is to go after the highest charge, to go after the highest sentence possible. And to your point, Rob, what is scary here is not only are you taking away the discretion of one of the 94 U.S. attorneys, appointed U.S. attorneys in this country, but also the AUSAs under them.
Every federal prosecutor in the country.
But by going back to we're going to charge mandatory minimums whenever we can, you have handcuffed the judges.
Right.
You have handcuffed the judges. And we see federal judge after federal judge.
Then
who
they're
have
going to
come out,
utilize 3553.
but they can't get below the mandatory minimum
Yeah,
on
they gotta
3553 unless there's a
mandatory.
safety valve and unless the prosecutor moves for the safety valve.
Yeah.
And so what you see is there's been
This is all bad. It's just bad.
Well, in the
bad
last couple
upon
of
bad.
years, you've seen a couple federal judges who have left the bench, who have been very vocal about this,
Yeah.
who have said this is a broken system that we have because I have to now sentence somebody who I don't believe.
In the sentence.
Yes.
I had a federal judge sentence somebody, and this was a number of years back under the guidelines, and he called me up. He said, Fickman, will you take an appointment on appeal? I said, sure, Judge. He said, I didn't want to sentence that person to what, but under the guidelines, the mandatory minimums, I had to see if you can reverse me. The judge asked me to reverse him because he had what's called a soul, and he couldn't live with himself with it. And unfortunately, it had been a plea. There was nothing I could do to undo it.
And you went to the Fifth Circus.
The Fifth Circuit.
And we can kind of use this as a way to get into the larger issue which happened yesterday. But you know, in looking at everything that's happening in the circus that is D.C. right now, when you see what happened with Sally Yates, you see what happened with James Comey. One of the things that strikes me, okay, about this whole thing.
God, if you can narrow it all down to one thing, that's amazing.
Well, here's what. I can't narrow it down to one thing, but this is something that really strikes me about this, is that now, because of Sally Yates getting fired,
Right.
because of Jim Comey getting fired, these two are now heroes, right?
I think, yeah.
Okay. But these are two people. You want to talk about perpetuating plea mills. Those are two people who have been career prosecutors, who have perpetuated this system of mandatory minimums, who have overcharged people, who have wrongfully charged people. I mean, Comey was one of the at the forefront of charging white-collar people with crimes that they could not ultimately stand up at the Second Circuit.
Well, it's the context. I mean,
I agree,
the whole
but
ball game has changed.
But it bothers me because
it bothers you that they're now heroes.
I
understand.
These are people who have perpetuated a system of putting people away, who charge crimes at the federal level under the Hobbs Act for robbery cases that should be prosecuted in state court, and they put them away for 120 years.
What does it show you? It shows you that there has to be something really, 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 really bad to make those that were doing bad look good because they were up against this thing that's really bad.
Or that how uninformed the American public truly is about the criminal justice system.
There's no question.
There's no limit on that.
And that's what really is sad, that that the American people they can see these people as heroes because they don't know what's been happening.
I'm not
with
sure
these career
anybody
justice
that's
people.
voted for Donald Trump sees Comey as a hero.
Probably not.
I mean, straight up.
But we're still talking about a minority in this country because we're going to talk about the election. We shouldn't, but I mean, okay. I mean, maybe 50% of those that can vote, and maybe half of that 50% or thereabouts voted for Trump. So maybe a fourth of the country actually supported him, less than a fourth, really. And so
He was elected, Rob.
Hey,
I know he was
no
right.
regrets.
yeah, and he said that they
Elected, bro.
Yeah, I know. To make America, I don't know what again.
No regrets.
But you know where we're at now?
Yeah.
Okay, so now we have a special prosecutor, special counsel, who's really going to function as a special prosecutor to investigate all this. And I think it's the best thing that's happened to our country since the day before the election. And because Mueller is highly respected.
Yes.
He worked under the Bush administration and the Obama administration. He's as straight a shooter as you'll find. He's not going to be intimidated or bullied. And what will be interesting to see, and I think all Americans should hope for the truth, whatever it is. I know I do. I certainly have my opinion about this cat named Trump, but
And we'll get to that in a
no,
second.
it's irrelevant. I hope that
This is an opinion show.
I hope that the investigation does get to the truth, because the American people need to know the truth, whatever it is. And there's what we have to watch for now is whether or not we have a repeat of what happened under Richard Nixon, because we're in the position where we have a president that does whatever he wants, whenever he wants, it appears, who has no constraints. And that's kind of like Nixon was back then. And Nixon told the Attorney General on the Saturday, when Saturday Night Massacre, he told the then Attorney General Elliot Richardson to fire the special prosecutor. And Elliot Richardson refused and resigned.
So on down the line
and then
until
he
the
went to
Solicitor General.
Ruckelhaus and told Ruckelhaus to fire him, and he resigned. And finally, they ended up with that guy Bork, who was sworn in as Attorney General, and he fired the Special Prosecutor Cox. And there was such an uproar in our country that that's how our local hero Leon Jaworski became the Special Prosecutor on the Watergate case. And so I think we're very much in the same territory, and it'll be interesting to see in the next month or two whether or not Trump tries to fire this special prosecutor, because there should be an absolute uproar if it does.
And I want to come back to this, but we got a phone call I want to take right now as well. Hello, thank you for calling Reasonable Doubt.
Hi, thank you for taking my call. I had a couple questions about what you were talking about in the beginning of your show in Harris County, and specifically about pretrial services. Just wondering, who are they supposed to serve? Is it a service department geared toward helping clients or defendants? Do they work for the judges? Do they work for the DA's office? They seem to have ex parte communications with the judges frequently, and also, in my experience, have gone to talk to clients in jail without attorney being present. Just wondering, what is the point of that department? I mean, why do they need to verify information when a PR bond should be granted, or in some cases already has been? Thank you.
Great, thanks for the call.
They have an extraordinary amount of power. Recently, I have seen them, and so what's happening now is the judges are just looking to them.
They work for the
answer.
judges at the end of the day.
Yes, and it's amazing that the judge, will spit out, he deserves a PR bond because of X, Y, and Z, and purely valid, 100% reasons. And the judge will then look to the PR representative, and they will say yay or nay, which is huge, and it has nothing to do with what about my arguments of X, Y, and Z that are completely compatible and valid under the law. However, pretrial comes and says yay or nay, and I've actually had some of them, and I respect a lot of them. They're good people, and they're trying to do the best they can, but they're being stretched really thin.
Well, I'm sorry.
Yeah, no.
Well, for many years, for all these years where we haven't been getting PR bonds for poor people or for any people, very few, the pretrial services was co-opted, and the judges used them to. What happened is the judges used pretrial services to oversee people who were on bond, surety bonds, like they hired a bondsman to get out of jail, and the judge would give them a bunch of conditions, sounded like they were already on probation. You have to do all these things while you're on bond. And they made pretrial services supervise that person that was on a surety bond. And so their job they were supposed to do, which was overseeing pretrial PR bonds, got shoved aside because of the minimal number of PR bonds, and they then became an aid basically to the bondsman, who we haven't mentioned here, but they have a big hand in all that's gone on here behind the scenes. But the bottom line is now pretrial services is trying to find its footing. They have a new head guy. I've spoken at length with the previous leader or our chief of that outfit, Carol Oler, who's very well-intentioned and fought for years to try to get the judges to grant PR bonds. And she ran up against a wall. It didn't matter what she said. And we've talked about it, that risk assessment was just as good as it needed to be. That's just, anyway, in answer to the lady's question, yeah, they work for the judges, but they're also supposed to be an honesty to it, where they're presenting to the judges an honest assessment. And the assessment became meaningless. I mean, if they're going to do an assessment and they know ahead of time that the judge is going to deny the person, then what's the point of even doing it?
There was a very gray line that I'm not sure that I'd like to discuss or get your opinions on, where the PR pretrial services came and said, Judge, he should get a PR bond, but at the same time, he needs some serious help. I think he needs help, and I am cautious about saying he should get a PR bond, even though he very well should get a PR bond.
Let's push pause right there and just go to another county. You make bond, you go to court.
Right.
There's no urine testing. Nobody
monitor.
sees you.
Yeah.
You're presumed innocent. Imagine that idea.
Yeah.
Their courts might be once a month or two. You just show up to court.
And what happens here, Todd?
Not that.
No. You go into court here. I walked into court here in the county court, and I saw a judge, this was a couple years back, and you're going to do this, and you're going to wear this electronic, this is on a misdemeanor.
Yeah.
You're going to wear this monitor on you that will detect if you have any alcohol in your system, and you're going to put a guardian interlock on your car.
When they're charged with theft.
When you're not alcohol related, you're going to call in once a week to pretrial service, or
Isn't
to
that
the
amazing?
pretrial people. You're going to do this. All these things, and I was like, man, this person's getting a tough probation. And then I listened to it, and they haven't been convicted of anything. These are their conditions while they are presumed innocent. And see what that shows? You see what that shows? It shows in Harris County, you're not really presumed innocent. When you walk into Harris County, you're presumed guilty. And if anybody thinks otherwise, well, you're living in some kind of dreamland. If you're in the county courts, looked like I kind of went nutty there. If you're in
Slightly.
the county courts, you're presumed guilty. And that's why they treat you that way. And that's why when you go in, a lot of times the bailiffs talk to you like you've just been found guilty of a crime. Sorry.
I think the
got a little
hunching over the
emotional
table
there.
is what really got it.
I had a guy.
I would say let's go back to the special prosecutor conversation, but I mean, now that we've got him really riled up.
No, I'm scared. Just pissed me off. Just got pissed off.
I had a guy comes to me. I'm not only not guilty. I'm actually innocent. DWI. It's okay. Let's go. He goes to it's a refusal. They take the blood. It takes 4 to 5 months. 6 months come along. He's had the breath machine. He's had the report. Blood alcohol level 0. Toxicology level 0. The man just spent 6 months of his life coming back to court every 2 or 3 weeks.
Yeah.
A machine, a reporting.
Wearing him down. They try to wear people
Wearing
down to plead
him
them to
down.
So even if you get bond, the judges try to wear you down by making you come every 3 weeks, whether you need to or not, because nothing happens every 3 weeks. And it's like for somebody that's holding a job, and then every time they got to explain to their boss, I got to go back to court. Why are you going back to court? For nothing.
Nothing.
For absolutely nothing.
Nothing.
So that my lawyer can try to get another reset until this case can be resolved.
I had another issue recently in Fort Bend. What they do is they make you don't even get a court. You're assigned to go to the Fort Bend courthouse at 8 a.m. You don't even get a courtroom until you're indicted.
Right.
You just go, you literally go to a table behind the escalator to check in once a month and for 4 to 5 months until you get indicted. I mean, and people are taking off work. People are having, and you get bond conditions.
In
It
another
works.
county, Jackson County, that's probably 70 miles down the road, you don't go unless and until you're indicted. You
Well,
don't have to show up.
Is that my level?
So the bottom line is everybody does it differently. The idea is, of course, we all understand that people are presumed innocent.
Well, the law says that, but in reality, I don't really believe people believe in it.
Well, but I don't think, but here's the thing. I also think that, unfortunately, the majority of jurors who walk in there don't believe it either.
Well, yeah, that's...
One of the
they don't
first
think the
questions I
judiciary-
ask them, Jimmy, when they come in there is, raise your hand if first thing you thought is, I wonder what he did.
Yeah, to be sitting here.
Well, and then I say, not me, because they usually wonder what I did.
Well, if you look at the
But
house...
they every time they raise their hand. So I asked them to rephrase it.
Yeah.
Perhaps you should thinking about, I wonder what they're accused of.
Yeah.
People don't walk in thinking that. They think, I wonder what they did. Let's see what we can do now.
I think our courthouse for so long has been so, for lack of a better word, redneck, backwards thinking that there is this incredible presumption of guilt in that courthouse. It starts from the moment people walk in, they're treated in an abusive manner, and when they get into the courtroom, they're treated in an abusive manner. When they get before the judge, many of these judges treat them in an abusive manner. Not all of them, but I'm sure a lot of, think of the innocent person that's sitting there and how they're treated in such an abusive manner, they don't feel like they're presumed innocent, because I don't think most of the judges actually do. And maybe the judges just get kind of tired because after a while, a lot of people do plead guilty. So maybe in the judge's mind, they just figure, well, probably most of them are guilty.
Yeah.
And that's not true. Because a lot of cases get dismissed that you folks out there in TV land never hear about. You don't hear about the dismissals that we get all the time.
I got 3 today.
Yeah, there you go, 3 today. Well, I got 70 today. So,
Damn. He just beat
He's not telling.
I actually did have 3.
They were all in traffic court.
I get a,
We got another phone call I want to get in here.
kind of big with that number.
Hello, thanks for calling Reasonable Doubt.
Real big.
How you guys doing tonight?
Great, how are you?
Good. Thanks for taking my call. I
Absolutely.
was just calling because I know Mr. Fickman's from Midland County,
Oh,
and I heard you guys on there talking about how tough it is there. We had a case up here where we had the case. It took 3 days. A jury came out, said not guilty, and within 2 minutes of the case, it was Mark Bennett. He said, "I'm going to file that expunction, for the right of expunsion." And the DA turns around and looks at him and says, "I'm going to object to the expunction."
Oh.
And we just had a case that took 3 or 4 days. You're talking about backwoods hicks. Come to Midland County.
Yeah, I was raised there, so
thanks for the call.
yeah.
Well, that DA is just wrong.
Yeah, DA was wrong.
Well,
I'm sure Mark educated him on the law.
Quickly.
Yeah.
I bet that pleading was filed the same day.
Mark would not back down.
No, probably not. But yeah, I mean, going back to it, I mean, the presumption of innocence, unfortunately, I think we all see it every day. It's just lip service.
I think that, you know what it connects to? It connects to where this conversation started tonight about the lawsuit. The lawsuit and the abuse of the poor in the misdemeanor courts is really an outgrowth of people being treated like they're presumed guilty. If the judges really thought these people were innocent, I think they would treat them in a different fashion, and they wouldn't so easily accept a guilty plea from somebody who was just 20 minutes before appointed a lawyer who the judge knows very well that lawyer hasn't investigated the facts, hasn't investigated the law. All they've done is gone back and conveyed the offer, and now they're coming out and pleading guilty, and the judge very happy to take your plea of guilty. Thank you very much. Next.
Well,
and I mean, the judges know that they have this person
agree.
has not had any legal representation.
And I don't want to, keep piling on the mainstream media as so many people do, but I do feel like that they are somewhat complicit in this, because when they cover murder investigations, the way they cover it, the angle of the story that they do puts the presumption of innocence and switches it around, where they report in such a fashion that I believe. I mean, look,
Everybody sounds guilty.
Well, and look, just as much as you hate Trump, the fact is the media's coverage of it.
I don't hate Trump. I just want him to move and never come.
but the media's coverage of
Pretty
it
sure I hate
has pretty much assured that nobody involved in this administration is going to get a fair trial. I mean, come on. The bottom line is Mike Flynn can't get a fair trial. He's already been convicted. He has.
I'll give him a fair trial. You can point me at
Special judge, huh?
I'll give him the fairest trial.
Look, I'm not a fan of Trump. I'm not a fan of the way he's doing things, but I'm just looking at it purely as a defense lawyer and saying, you know what? I mean, if I was Mike Flynn's lawyer, there is no way we can get a fair trial in any jurisdiction in this country.
Well, it wouldn't matter where you went, but you know what I said earlier is I hope that the man that they appointed as special counsel, he has a great sterling reputation. I hope he gets to the truth, whatever the truth is.
Right.
So we have to, we're in a way, our Constitution is kicking in, and I think that's a really good thing. We're not being ruled. Trump is not the ruler. He was elected president. People need to remind him of that, or try to. But I think what we're showing here is that, we're going to have an honest investigation. I think the person they appointed will do an honest investigation. And I think as Americans, we should all hope for that. If Mr. Flynn is not guilty and he didn't commit any crimes, then he should be cleared. Same thing for Trump. As much as I dislike him, as much as I think he's guilty, if he's not guilty, he should be cleared by the investigation.
Let's say it this way, Jimmy, to kind of highlight your ideas. If the presumption is of guilt in our society as it floats around the air, we know, especially us sitting at the table, and most criminal practitioners that care enough in this state, in this county, in our nation, we see not guilties every day in courtrooms across the country, right?
Correct.
And perhaps we have 15 minutes to talk to a jury, maybe an hour to talk to a jury. To me, it's always been the more higher the charge, the more a jury considers the presumption of innocence and things like this. I do believe that even if they walk in with that presumption of guilt, which especially with the example I just raised, I believe a good lawyer with good tools can set the tone to show this jury that, yes, they need to strictly abide by that presumption of innocence.
I agree.
And
That's the lawyer's job, is basically to get the jury to follow the law and presume their client is innocent.
And as we know that there's not guilties around our nation, that's happening.
Right.
But that means that we're not going in on the same side as our potential juror panel. We're having to educate and teach in short time frames.
Yeah, and I read something the other day, and we only got about a minute left before we have to get out of here. I mean, it's flown by like that. But I read an interesting perspective on it, and it said, remember what you're trying to do, and you have to get your client to understand this. We're never going to be able to prove your innocence. We're not here to prove innocence. The state is here to try and prove you guilty. And, you have to get them out of the mindset that we're ever going to be able, your client's not going to walk out. The best they're going to get is not guilty. They're never going to walk out with a piece of paper that says you're innocent. This is not going to happen. And
It's not on the list.
Yeah.
it's not on the list. We're going to wrap things up, guys, but I appreciate you coming on this program tonight. It was,
Thank
it
you
was an
for
honor
that.
to have
I'm
both
sorry
you guys
that
on.
I almost crawled into the camera.
It's all right. We need to have
Apologize.
we like to have animated people on this program. But appreciate Robb Fickman, Todd Dupont, stopping by tonight. We'll be back next week, ladies and gentlemen. Another new episode of Reasonable Doubt for your viewing pleasure. Come and join us next week. Check us out on Facebook and follow us on Twitter and send us some messages there. Good night, everybody. We'll see you next week.
All right.